Hello, my name is Joe Gaspari. I am one of the financial consultants of the Alliant Retirement and Investment Services team. Today, we're going to be talking about the basics of estate planning. And hopefully this will be a little guideline for you just to see, do I need to speak to a professional about setting up wills, trusts, things like that? But hopefully this is just to make you think a little bit. It's not going to be very detailed, but hopefully enough just to make you think, do I need to have a conversation? And hopefully you and I can even have a future conversation about digging into a little bit more in detail about maybe guiding you of what you can maybe ask an attorney about setting up wills and trusts and what might be appropriate for you. So before we do get started, I do want to let you know that we do have webinars coming up in the future. We have many of us that do these webinars, and some of these might be at a lunch hour in the early afternoon. Some of them might be in an evening. Hopefully we can do it at a convenient time for you, but please check out to see when those are available in your area. Investment Savvy Podcast, we do have a podcast that's available to you and our website and blog as well. Today's agenda, we're going to be talking about the basics of estate planning, 6 things you need to know about estate planning, living trust, duties of a living trust executor or trustee. Estate planning in a nutshell, designate who will receive your assets. Very important to make sure that you have this done, and certainly something that could be edited in the future or changed. If your beneficiaries need to be changed, make sure beneficiaries receive assets in the most cost-effective way, whether that's just a will, whether that's setting up a trust. I'll give a couple of examples a little bit later on of my personal situation, both personally and professionally, of my family and with clients that I've worked with on some of the things that have come up regarding estate planning. Can fine-tune your plan as you go. So number 1, the 6 things you need to know about estate planning. Beware of probate. Very important. Hopefully you can do as much as you can to avoid probate. It's a very timely and costly thing that you could potentially go through. Creating a will. Decide on the beneficiaries of your assets. Consider creating a revocable trust and considering powers of attorney, whether that is for your financial power of attorney or your healthcare power of attorney. Those are 2 separate documents. Very important to know the distinction between those and have the talk basically about our death. It's certainly something, where none of us are going to get out of this life alive, and it's certainly something that we need to have that discussion with your loved ones or your beneficiaries or whoever's going to be handling your estate when you do go. Beware of probate. Process the court uses to settle the deceased estate. Settlement time and expense can vary by state and situation. I can say that I've gone through this with my parents. My father passed away in 2015. My mother passed away in 2016, a year later. Some things that her health had quickly gone down after my father passed away. But she didn't get to everything, we found out. And there were some things that did not have beneficiaries named or things that were changed. And it was just life happened, and she got sick, and we just didn't get to everything. But her estate did go through probate. It was about $300,000 worth of assets that did go through probate. And it took about 6 months to get this settled. And it cost us about $9,000 in attorney fees. So it's certainly something. Probate is not a fun thing. She did have a will. That will was updated, but a will still go through probate. So very important to be aware of probate. Creating a will, like I said, even creating a will, your estate still can go through probate. It does serve as a guide for your final wishes. It does not avoid probate, but does make things easier. Certainly it can, but a will can be contested, which could drag out the time that it is in probate, and certainly could drag out and increase the expenses attached to that. It can help eliminate and potentially any family disputes, which I've seen many of those with many of my clients and families. Make sure all of your assets have beneficiaries formally named in other documents. Just because you have a will, you do have to make sure that all of your accounts have beneficiaries named on them. And deciding on the beneficiaries of your assets, you do need to make sure that each account has beneficiaries named, and especially in all these different types of accounts. IRAs, 401ks, very important to have your beneficiaries named, and there are different rules about inheriting an IRA and a 401k. Don't forget about the everyday assets. You also should have beneficiaries named on savings and checking accounts, or potentially even have an adult child joint on a savings or checking account. That's what I've seen many of my clients have had as well. That way it can even bypass a power of attorney, that if you happen to be in the hospital and there are some assets that a child or a family member might be on with you, that person has access to some funds that they can continue paying bills for you, even if you're not capable. Separately, consider creating a list of all of your accounts with a password or PIN. Of course, keep that stuff secure. The privacy is absolutely ultra important, but just making sure that family members or whoever is settling your estate, or even if you are incapacitated, just to make sure someone knows where to find things. The golden rule of estate planning: make sure your beneficiary designations are always up to date. The birth of children could add more beneficiaries. If someone passes away before you that have been one of your beneficiaries, you absolutely should be updating those types of accounts. Marriages, whether you are remarried, a second marriage, or if your children are married. Now, here's a couple of examples on that if you do get married yourself, remarried, and is that person going to be the beneficiary, or are your children going to be the beneficiary? And also, if your children happen to be married, I've seen many situations where if you have adult children that are married, and those in your children have children, grandchildren for you, you might want to make sure, or some of my clients have wanted to make sure, that if that child passes away, will the assets go to your child's spouse, or will it go down to the grandchildren? And there are steps that you can take to make sure that whichever way you want that to happen, it will happen. So there are certainly things, whether you are remarried, whether your children are married, where you want assets to go. Divorce situations. I've seen a divorce situation where a husband was married, they got divorced, he ended up getting remarried, and about 10 years later, he passed away. And the ex-wife was still the beneficiary on his life insurance. Don't know how that ended up, because I know there was a lot of attorneys involved on that type of situation, but making sure that all beneficiaries are updated as life changes. And if you are incapacitated for any reason, you want to make sure that things are already set in place if you're not able to do that. Make sure your beneficiary designations are always up to date. Even don't forget about those other things. You can set beneficiaries on those other assets that typically don't have beneficiaries, or not normally anyway, but cars, boats, and other valuable items. You might want to make sure that things are documented in the correct way to make sure these things pass to your beneficiaries the way you wish them to pass. A quick word about taxes. Taxes, when someone passes away, there's a few different examples here. Primary residence and qualified retirement plans are likely your two largest assets, handled very different from a tax perspective. Real estate can receive what is called a step up in value. And here's an example of, again, my mother. When she passed away, they bought their little condo in Florida for about $135,000 when they moved in there years ago. When my mother passed away, we had to get an appraisal on that property. We got an appraisal on that property, and it was about $220,000. Because when she passed away and we were going to be inheriting, as the children inheriting this property, it turned into a non-owner occupied, or technically an investment property. And there could be taxable gains or losses on selling this property. So we don't have to worry about that she bought it at $135,000. We had to worry about what the value was at the time of her death. So the attorney instructed us to get an appraisal on that condo, which was about $220,000. And we ended up selling it. Actually, we sold it for $212,000. So our cost basis, it started at 220. That's technically what we quote unquote owned it at initially. And we sold it for 212. We actually had a tax loss. So it didn't go by the 135,000 that they bought it for. It went from the 220,000 that it was valued at the time of death. And then we sold it. If we sold it for more or less than that, then it would have been based on that value. Heirs can avoid capital gains, so we did avoid capital gains on that with that situation. IRAs and 401ks are taxed very differently. If your spouse inherits an IRA, there are withdrawal rules for a spouse. If children or anyone else inherits that IRA, there are different rules on withdrawal requirements. So you do want to be aware of those. We can certainly have a discussion about those if you choose to, but just so you know that 401ks and IRAs have they have rules based on who the beneficiary is that is receiving these assets. Estate planning expert or a financial planner can certainly help. It's certainly something you and I can have a discussion one-on-one about getting started on some of these things. Consider creating a revocable trust, also known as a living trust. And one of the reasons they might call it a living trust is that when people die, the living trust or the trust can keep on going. What you would do is if you are living and you have a trust, you might be what's called the trustee of that. Or if it's a spousal situation, you might have what are called co-trustees on that. If you passed away or both of you passed away, you would name in that trust what are called successor trustees. And that successor trustee, upon your death, that trust is still going, takes over, and might distribute assets according to your wishes. However, wording is described in that trust, but that trust can keep going on even after your death. So that's one of the reasons why they might call that a living trust. Typically considered for larger physical assets such as your home, car. You cannot name a 401k or an IRA in a trust, but you can put savings accounts in a trust or brokerage accounts in a trust. You're going to name the trustees, whether it's yourselves, and you would name what are called successor trustees again on those accounts or in that trust to make sure you have a trusted person controlling everything upon your death. So the trustee does retain control and will help transfer ownership of the assets upon the trust owner's death. You can make for a smoother transition of ownership, and a trust will avoid probate. So you don't have to go through, if the assets are in the trust, you name beneficiaries in the trust, then that will certainly avoid probate. Consider having a power of attorney drawn up. Now, again, there are two powers of attorney. One is a durable power of attorney, basically for your assets, and the other is the healthcare power of attorney, who's going to control things if you are incapacitated. What if you need a surgery? What if anything happens to you medically and you're not able to make that decision yourself? Is someone designated to make that decision for you? And these are, again, two separate documents, and one might go to the hospital or a doctor to do. That would be the healthcare power of attorney, and the durable power of attorney would be for your banks or credit unions or brokerage accounts. Can you do financial transactions for someone that it is not able to if you have power of attorney for that? So these are two very separate documents. The durable power of attorney gives the agent the power to transact real estate, enter the financial transactions, and make other legal decisions on your behalf. It is irrevocable. You can change the person who is your power of attorney. So if you name someone, maybe that person passed away, or just for whatever reason you wanted to make someone else the power of attorney, you can certainly change that. And it can be anyone you trust. It could be a family member, friend, any other relative, so you can name anyone. The healthcare power of attorney typically might be a spouse or partner or family member that is going to be looking out for your health well-being. Someone you trust who knows your views and issues on the do not resuscitate. I've seen family issues of, does someone want extra measures taken? If someone needs CPR, do they want to be intubated or anything like that? Can be all documented within the healthcare power of attorney. and the backup agent should also be identified. So we have that in powers of attorney and wills and documents that we have personally, my wife and myself, that we do have someone named as the power of attorney, but then we have, if this person is not able to, that someone else, we did name someone else that could then act as the power of attorney. Having the talk, perhaps the most important part of the estate planning process. It's tough but necessary. Aging parents or relatives should absolutely have someone taking or helping them look over their assets and their health care to make sure a trusted person it knows where things are, where accounts are, knows who you want as beneficiaries, and will make sure things pass to those beneficiaries in a very effective manner. Living trusts. Living trust could be a very important thing to explore. Becoming much more popular, avoids court interference, so no probate if assets are in a trust. They're very flexible. You can make changes along the way. Again, if beneficiaries passed away before you, you can certainly make changes. Maybe charitable organizations might be very important to you. So it's something that you can name, 501c3, companies out there that could certainly be beneficiaries in your estate or in that trust. And again, very flexible. The basics of knowing how a living trust works acts very much like a will, except for this is a legal entity that can own assets. It's almost like if you had a separate business account. If I'm Joe and I have Joe's business, I can have Joe personal accounts and I can have Joe business accounts. Very similar to having a trust. I have Joe and then I have the Joe Trust, where the trust own the assets, but I'm the trustee of that. So it's a separate entity that can own the assets. You must transfer assets into it. So if you do see an attorney and create a trust, it would have a specific name and the date of that trust. You can go to each financial institution that you have. You can go to those and say, here's my copy of my trust. I want to put assets into this trust. I want to put this savings account or this brokerage account into the trust, which you would have to do. Titles must be changed from your individual name to the name of the trust. Can make settling your affairs much easier upon death or incapacitation because it avoids probate. Again, very important to do. It's a little more costly to do a trust than just a simple will or power of attorney. There might be some extra fees, but again, if you recall when I said that we paid $9,000 in attorney fees for probate, it would have been much less if we, let's say she was able to do a trust, even though she was ill, but it might have cost her $2,000 or $2,500, but a lot less cost than what we did pay for probate. The duties of a living trust executor or trustee. In incapacity of your surviving parent, you oversee their health care, understand insurance benefits and limitations, look after dependents. There might be dependents of someone that is incapacitated or pass away. Who is going to look over those the dependents? Maybe it's an adult child that's with disabilities that someone needs to look over. Apply for disability benefits, notify the bank or other financial intermediaries making sure that the power of attorney is in place, that if you can act on behalf of that person, transact necessary business, keep accurate records and accounting. If the death of a surviving parent, contact the attorney to review the trust and process if needed. Keep beneficiaries informed. Inventory assets, determine the current values. Again, upon death, there's a step up, as I stated on that step up in cost basis of that property that my mother owned, the condo. It's the same thing with brokerage accounts. I've worked with clients that, a specific client that I had whose aunt was elderly and in a nursing home and had a brokerage account that was not a retirement account, but it was in the several $100,000 value. And in that account were several stocks that the woman owned for several years, and there was huge capital gains on some of these. old oil stocks, things like that, that she bought. Let's, as an example, if she bought a stock for 50,000 and it was worth 125,000, and there's a 75,000 gain. So if she as a living person sold that stock, she would have to pay capital gains taxes on approximately 75,000. When she passed away, that stepped up to $125,000 cost basis. They could sell the stock immediately at zero taxable gain. So again, there's that step up available on brokerage accounts as well. You want to collect benefits, keep records, file tax returns, paying bills, do final accounting, distribute assets to the beneficiaries as the trust directs. And very important, as the trust directs, you have to follow the laws on those. Is that if the people creating the trust had specific wishes, those have to be kept. Get help if you think you need it. You don't have it, you don't have to go it alone. Consult with accountants, investment professionals, and attorneys as needed. Your LPL Financial Services professional, I can certainly help you with some of these getting started. A final thought, take care of your estate in order to take care of your loved ones. That brings us to the end of the presentation. Thank you so much for your time and regarding this. And again, here's a little bit of our information about what is available through Alliant Retirement and Investment Services. And my contact information is on the screen. Please reach out to me if you have any questions, thoughts, comments, and how I can help you here. Thank you so much.